Good afternoon, Your Honor. Alex Lauren Green on behalf of Mr. Magoo. Thank you. Mr. Magoo, can you state?
Daniel Magoo.
Thank you.
Your Honor, the defense is ready to proceed to examination in each matter. I'd ask for a sequestration order.
I anticipate one witness in each case.
All right.
So it should be open.
All right. Witnesses are ordered sequestered for what that matter.
Actually, Your Honor, I have
You may have.
All right, guys, buckle up. Today, we're diving into a courtroom showdown featuring Daniel Magoo. Right out the gate, defense counsel Green declares readiness and calls for sequestration. The judge agrees, clearing the way for testimony. Tension builds as the tone is set. This won't be an ordinary OWI trial, but battle of strategy, law, and credibility. Everyone braces for a long contest.
Yes.
I have an issue. I have been requesting the last time I was here, requested that the prosecution provide explanation for the undue delay.
Your Honor, my advice to Mr. Magoo is that I'd be handling the examination today, so just for purposes of the record, I'm advising you not to make any statements on the record.
Well, I do actually also want to provide notice that this case is being removed under 28 USC 1455 to the Eastern District of Michigan under case number 25-12440, and due to due process violations that I've been facing.
I don't know what you're talking about. The case has been removed.
I'm sorry. I'm providing notice of removal of case number 25-12-12440.
Have you talked that over with your attorney?
I let him know.
Your Honor, and my advice was I'm not going to be joining in any collateral motions or actions, and that I would address the case.
Are you aware of any motion that seeks to take this case to federal court? I'm not sure how that would even happen.
Right, Your Honor. And Mr. Magoo told me that he has been seeking that action, but I informed him that I am not a member of the federal bar and that I would not be joining him in any of those actions.
Just providing notice.
Okay, I don't know what the notice does, but I'm not. If I don't have something in writing indicating some procedural aspect to it or anything along those lines, the court's not.
Can I give this to you now?
I would advise against.
I don't even know what is.
Notice of removal pursuant to 28 USC 1455 criminal.
What does that statute read?
The criminal proceedings removed to federal court under federal questions.
In this segment, Magoo tries to derail the process with a bold notice of removal to federal court. The judge, unimpressed, explains that until higher authority intervenes, the case stays right where it is. Defense counsel distances himself, stressing he won't join federal antics. The scene highlights courtroom reality. Paperwork games won't halt the march of justice. Authority stays grounded in state law.
Involved in this case.
I'm not going to bite as to what federal questions, because I don't think there are any federal questions.
Fourth Amendment violation.
Which adequately a state court could handle if that were an issue. So I don't think there's any need for the court to even deal with that. I don't know that anything's been filed with the federal court regarding that or anything else.
Filed under case number 25-12440. Eastern District of Michigan.
Are we ready to proceed?
Defense is ready to proceed, Your Honor.
You go ready to proceed?
Yes, Your Honor.
All right. Which case would you?
We were talking over each other. I apologize. If it pleases the court, could we start with the OWI matter?
That being 0523.
I believe that's correct. Yes, sir.
Here, focus shifts to the OWI case. The court confirms it's proceeding under case 0523, and housekeeping follows. Amended information is filed, and both sides stipulate the prior convictions and exhibits, photos, and a lab report. These moves tighten the narrative of guilt even before testimony begins. The foundation of evidence now stands locked, setting the stage for direct confrontation.
That's fine. Start with that one.
Thank you. A couple of housekeeping matters. The court is in receipt of the amended complaint, which is just taking it rather than a felony form. Is that correct?
I do have an amended information. I do.
Excellent. And, Your Honor, I do believe defense is stipulating that the defendant has 3 prior OWI convictions.
So stipulated, Your Honor.
So there's a step to the priors.
There it is, Your Honor.
All right. Anything else?
I do think defense is going to stipulate to People's Exhibits 1 through 10, which are photos, but maybe not.
Your Honor, I did have an opportunity to review those and we would so stipulate.
And then People's Exhibit 11 is a laboratory report. I'm not sure if there'll be a stipulation to that as well.
We would so stipulate.
I'm sorry?
So stipulated, Your Honor.
Okay, so exhibits 1 through 11 are stipulated to.
Thank you, Your Honor.
Therefore admitted.
Thank you. I do expect that the officer in charge of the other matter will probably be informed at some point if sequestration order is otherwise enacted and followed. So I will call Paul Corey to the stand.
All right, please come forward to be sworn.
Officer Paul Corey takes the stand as the first witness. He recalls being dispatched just past 1:30 a.m. to Dexter and Arona. The scene: an SUV slammed into a sign at a gas station, a lone male lingering nearby. The officer's words start weaving a timeline the jury can picture. Every detail adds layers of credibility to the prosecution's opening salvo.
You saw the swear affirm testimony about the truth,
Were you working for the Milan City Police Department on or about March the 27th, 2024?
I was,
Do you recall what shift you were working that day?
midnight shift, 6 p.m. to 6 a.m.
And were you ever at the location of Dexter Street and Arcona Road?
I was.
About what time were you at that location?
About 1:35, or when I was dispatched there.
Why were you dispatched there?
The 911 caller had said that there was a single car crash into near a gas station in that area.
Did the 911 caller, did you have any other information in your dispatch when you were headed that way?
Objection, Your Honor. Calls for hearsay.
Your Honor, it's not being offered to prove the truth of the matter asserted. It's being offered to prove why he was headed to that location and other additional information that may have hastened his speed going that way.
All right, I will overrule the objection regarding hearsay. I'll accept it for what it's offered for, other than the truth of the matter.
Thank you. Did you have any other information from the dispatch?
I believe that the caller said that there was a single subject walking around outside of the car and potentially, possibly injured.
When you arrived, what did you observe?
A car that was, I saw a SUV that was appeared to have been crashed into a sign outside the gas station here, Dexter, and there was a single male subject standing around the passenger side of the vehicle.
What did you notice about the vehicle first?
It was definitely crashed there and not parked. There was some extensive front end damage.
Officer Corey, you took some photographs that evening.
Yes,
Did you take a photograph of the vehicle as you found it?
I did.
Actually, more than one, would that be fair to say? All right. And when you saw the vehicle, how did you determine that it had been crashed as opposed to just parked there?
Due to the amount of front end damage that it had, and it was still in contact with the signage there.
Did you make any observations about any other parts of the vehicle?
There was the windshield was smashed and
The officer paints a vivid picture. Front-end damage locked against a sign, windshield shattered outward, and hair stuck in cracks. Inside, personal property suggested only one occupant. These details drive home impact and occupancy, linking McCoo to the driver's seat without direct confession. The testimony gives jurors something physical to hold on to, clear evidence of force, injury, and presence.
particular fashion.
And but
It appeared that it was impacted from the inside rather than the outside.
how could you tell that it was impacted from the inside rather than the outside?
It was falling outward instead of inward, and there was no like gouging from the outside.
And when you were looking at the windshield, would you describe the cracking in any particular way?
In circular fashion. It's front of the driver's seat.
Did you look inside of the vehicle?
Yes.
Where did you observe about the inside of the vehicle?
There was quite a bit of personal property inside of the vehicle, and the passenger, and all of the front and rear passenger seats, indicating that there was probably only one occupant at the time of the crash.
Did you look at the windshield?
Yes.
What did you observe about the windshield?
What stood out about the windshield was there was a clump of human hair attached to the cracks in the impact area on the inside of the windshield.
How would you characterize the color of the hair that you saw?
Light brown, maybe dark blonde.
Did you make contact with any people at that location?
Yes, there was a male subject standing near the passenger side of the vehicle when I arrived.
Do you see that person in the courtroom today? Can you tell me where that person is sitting and what they are wearing?
Seated at the defense table wearing the green jumpsuit.
Your Honor, may the record reflect that witnesses identified the defendant?
No objection, Your Honor.
Record shall so reflect.
And sir, when you made contact with the defendant, what did you talk with him about, or what did he do?
I asked him what had happened.
What did he say?
He said he was bleeding from a cut or some type of injury. There was a lot of blood. It was kind of hard to tell where it all was coming from. It appeared it was bleeding from the top of the head.
Did you notice anything about his clothing?
It was disheveled. There was blood on it. Front zipper was down. The zipper was down on his pants.
Did you look at the color of his hair?
Yes.
Based on your observations, did that appear consistent with the color of the hair in the glass inside the car? What happened next?
He maintained that he was not driving the vehicle. He could smell the odor of intoxicants coming from him.
Corey identifies McCoo in court and recounts his odd denial. I wasn't here. Blood on clothes, zipper down, wounds on his head, odor of alcohol. It all screamed impairment. Even the hair color matched the strands in the windshield. The officer's words paint a portrait of guilt that seems almost undeniable. Yet, the absence of sobriety tests leaves cracks for defense to explore.
We called for medical assistance just based on his injuries. And so while they were on the way, asked if he would take a preliminary breath test, which he agreed to.
Without getting into the results of the preliminary breath test, did you make a determination about what had happened that evening?
It appeared on his face that he was driving the vehicle and it got into a crash. And he may have been intoxicated while he was doing it.
Did you place him under arrest for OWI?
Not at that time.
When did you place him under arrest for OWI?
After the ambulance came, it was determined he was going to go to the hospital while he was receiving medical treatment, and I read him his chemical test rights. I advised him at that point that he was under arrest.
Did he agree to take a test?
No.
What happened?
He refused to take a test. Poor judgment on my part. I did not have him restrained in the hospital bed. Well, I left I believe that his injuries were significant enough that he was not going anywhere. I went out to my car to start preparing a search warrant for his blood, at which point a nurse came out and told me that he had fled the hospital.
The turning point. At the hospital, McCoo refuses chemical testing. Left briefly unrestrained, he vanishes into the night, only to be found 40 minutes later at an apartment complex. This escape is damning. It looks like consciousness of guilt. Jurors don't easily forgive flight, and prosecutors know it. The image of a man fleeing medical staff adds drama to the state's narrative.
Did you find him?
With some assistance from Washtenaw County Sheriff's Office, yes, I did.
Where did you find him?
An apartment complex just south of the hospital.
Were you able to take him back to the hospital?
Yes.
And did you complete your search warrant?
Yes.
Was it executed?
I just a note for the court, Sergeant Crusadis or it helped me prepare the search warrant while I was dealing with Mr. McCune at the hospital. However, I did review, since I was going to the warrant, I did review it to make sure it was accurate based on my observations at the time of the incident.
Did he make I'm sorry, go ahead. No, I'm so sorry to interrupt you, sir. While you were waiting to do the blood draw, did he make any statements to you?
He looked at my uniform and appeared to be confused as to why he questioned me as to why Milan, the city of Milan, was doing all of this. And
What did you say to him?
asked him where he thought he was, and I said he was insane. He thought he was insane.
Did you ask him to perform standardized field sobriety tests?
I did not.
Why not?
Mainly due to his injuries, and even though he did comply with the request for a PBT, he was generally uncooperative with most things that we were trying to get him to do, and asking questions about what had happened. Then based on the extent of his injuries, we were more concerned about getting him medical attention at that point.
In your training and experience with administering standardized field sobriety tests with people who've been in traffic crashes that have injuries, is there any guidance that you've received from NHTSA on that?
It can be, especially with what was clearly a head injury that was sustained in a vehicle crash, it could have impacted the results of the standardized field sobriety tests.
Your Honor, may I approach with People's Exhibit 11, the laboratory report?
You may.
And Officer Corey, you did receive a laboratory report back in this case? And do you recall what the VAC was?
I believe it was .127.
Or what was done with the vehicle? Let me ask that. Do you know what happened with the license plate?
We confiscated the plate as the operator at the time, who we believed to be Mr. Magoo, had several prior convictions for suspension and operating while intoxicated, requiring a plate confiscation.
Pursuant to state law, you had to take it. Your Honor, may I have a moment?
May. I do have one question. How much time elapsed between the time you were notified that he had left the hospital and when he was located? Do you know?
The blood draw finally occurs just after 4:28 a.m., clocking McCoo at a staggering .167 BAC. Vehicle plates are confiscated under law due to his priors. This evidence is powerful, scientific, objective, hard to shake. But the defense now has something tangible. Nearly 1 hour of freedom where anything could have happened. That timeline gap lingers like smoke, raising silent questions.
I believe it was about 40 minutes, Your Honor.
40 minutes?
40, yes, Your Honor.
Okay. All right.
And Your Honor, I will pass the witness.
All right, cross-examination.
Thank you, Your Honor. May I inquire? Afternoon, officer. My name is Alex Warren Green. I represent Mr. Magoo in this case. So you're dispatched for a single vehicle accident, right?
Right.
And that's at a mobile gas station, and it appears there was an accident from an SUV into the sign, the mobile sign, right?
Right.
And like you testified on direct examination, there was a 911 call placed, and that person didn't provide a name, did they?
They may have. It's something that I didn't end up following up on.
So you never talked to the caller, did you? And are you aware if anyone talked to that caller?
I am not aware that anyone did.
So as soon as you get there, Mr. Magoo is on the passenger side of the vehicle, right?
Standing outside. It's on the passenger side.
Okay. And that car was not registered to Mr. Magoo, was it?
Correct. It was not.
And like you testified on direct examination, he had a wound to his head, right?
Yes.
It's bleeding pretty bad.
Yes.
There was an injury to the front and back of his head, right?
There's photographs of an injury to the back of his head, yes.
Okay.
And the front.
And he appeared to be dazed.
Yes, it was difficult to say if he was out of it due to the head injury or his level of intoxication, maybe a bit of both.
And you didn't conduct the field sobriety test because you were concerned that the head injury you observed might impact the field sobriety test, right?
It was possible, yes.
So You testified on direct examination, you saw the windshield was smashed and you saw blood, right?
Correct.
There's a chunk of hair in the windshield, right?
Yes.
You take a picture of that?
Yes. Let me backtrack. Sergeant Mercedes actually took the photograph of it.
And most of the time you're talking to Mr. Magoo, he was wearing a hat. You recall that, right?
I don't recall that. You may have been.
So it's dark outside, right? And
You said a yes. I don't think we got it.
Oh, I'm sorry, Your Honor.
It's okay.
Yes, it was.
Okay, go ahead.
and there's a significant amount of blood on his face and it's going into his hair, right?
Correct.
Okay. In this case, you did submit evidence to the crime lab for forensic analysis, right?
Blood test, yes, blood sample.
Right. So no hair follicles, right?
No.
And there was no attempt to obtain any forensic match between the hair or the blood that was found in the car with any hair or blood from Mr. Magoo's body, was there?
You're correct, there was not.
Okay. On direct examination, you talked about field sobriety tests. You said you're trained in the administration of field sobriety tests, right?
Yes.
And you forewent the field sobriety tests in this case, but no one asked him at all to perform those field sobriety tests, did they?
That's correct.
And after this initial interaction, when, the ambulance arrives, he goes to Trinity Ann Arbor Hospital, right?
Correct.
And did you accompany him in the ambulance or you follow behind?
All behind.
Okay. And you read him his chemical rights at the hospital while he's in the bed, correct?
Correct.
And he refused at 2:51 a.m. Is
That's
that?
correct.
And after he refuses, you leave the room to go and work on the affidavit for the search warrant, right?
Correct.
And then Mr. Magoo vanishes.
That is also.
Okay. You didn't see him leave.
I did not.
You had no idea where he was.
No.
And like you said, he wasn't handcuffed or in any way restrained to that bed, was he?
He was not.
And there were no officers standing at the door or otherwise supervising that room, were there?
No.
And through your investigation, you determined he's located at an apartment complex at around 3:40 a.m., is that right?
That's what is in the report. I think I listed a time in there. If you want me to look at, refresh my memory.
It would refresh your recollection to look at your report?
It will.
Okay.
Yes, I did. He was located about 3:40 a.m.
Okay. And he's returned to the hospital. The blood draw was completed at 4:28 a.m. And of course, there's two blood draws done. So it's 4:28 a.m. and 4:29 a.m. Does that sound right, officer?
That sounds correct.
Okay. So in an ideal OWI investigation, you want to have eyes on the subject from the time you make the scene until the needle enters the arm, right?
I do, yes.
Okay. One of the reasons you do that is to make sure the subject doesn't consume anything that could impact the blood test, right?
That is correct.
And Mr. Magoo was unaccounted for nearly an hour in this case, right?
That's correct.
And in your search warrant affidavit, you didn't mention that, did you?
I don't believe so, no.
Cross-examination cuts sharp. Green underscores weaknesses. The officer never interviewed the 911 caller. The SUV wasn't registered to McCoo. Forensic analysis of hair wasn't done. No field test administered. And the escape gap creates doubt about BAC reliability. Each question chips at the edges of certainty. The defense doesn't have to prove innocence, only to make the jury hesitate.
Thank you, Your Honor. Officer Corey, were you able to obtain information that the defendant had previously been pulled over by a different police agency operating this car in March of 2023?
I did not.
And after he was recovered and brought back to the hospital, did you have two deputies stand by with him and handcuff him to the gurney?
I handcuffed him myself, but luckily I had a couple of deputies that were free for the moment that were able to watch him while I finished up the search warrant.
Thank you. Nothing further, Your Honor.
Anything?
Your Honor, if I may, one.
May want to mute your microphone.
Your Honor, just briefly. Thank you.
Officer,
Oh, and can I just ask one other question before you, and I'll let you ask your
of
question.
course, Your Honor.
The PT, if there's,
Alex, muted.
okay, the PBT, are people going to seek admission of that if defense is challenging the results
Yes, Your Honor.
pursuant to the statute?
Correct.
And Your Honor, I understand that the people could rebut that kind of challenge. I'm not sure that we have gotten to that point yet. The case law.
Well, I just want to make sure that if there is going to be a challenge to the results, that under the statute, my understanding is, although these aren't entirely the circumstance under which it happens, but it seems to me an analysis could be made that the PBT would then become admissible. Just so that defense counsel is aware, but you may inquire.
Thank you, Your Honor. I appreciate it.
Officer, before Mr. Magoo was admitted to the hospital, did you yourself?
Redirect seeks to patch holes, linking McCoo to prior operation of the same car and confirming deputies restrained him afterward. The judge hints PBD results may enter if challenged. The prosecution regroups, but the defense has left marks. This trial is a chess match, each move shifting momentum. And that's the breakdown. Don't forget to like this video, subscribe to the channel, and we'll see you in the next one.